In December, 99,000 patients had their health records taken, no break-in, just valid credentials, and nothing watching. The Privacy Commissioner called his strongest enforcement tool a $10,000 fine. He is asking Parliament for millions. 3 reforms are already moving, so the fine is coming. Is your board ready for it?
Let's get into it.
On 4th of June 2026, New Zealand's Privacy Commissioner told the public plainly that the law he enforces is not strong enough. This is the Hamberger Report. I'm Andreas Hamberger, Enterprise Architect and Board Governance Advisor, Wellington. Declared serious privacy breaches in New Zealand rose 43% in a single year. The Manage My Health inquiry confirmed 99,416 patients affected. The strongest enforcement tool the Commissioner currently holds is a compliance notice leading to a $10,000 fine. That figure is not the penalty for the breach, it is the penalty for failing to tell the Commissioner about the breach. The Act attaches no financial consequence to the organization that caused the harm. The Commissioner is asking Parliament to change that, and 3 government processes are already in motion. The enforcement architecture governing how New Zealand responds to a serious privacy breach is structurally weaker than the tools available to equivalent regulators in comparable jurisdictions. This episode is about why that gap exists, what is changing, and what boards need to do before the fine arrives. The Privacy Act 2020 operates on a mediation-first model. A complaint goes to the Commissioner. A compliance notice follows if warranted. Failure to comply is a criminal offense carrying a maximum fine of $10,000. Where a complaint is unresolved, the aggrieved individual may take it to the Human Rights Review Tribunal, which can award damages of up to $350,000 per proceeding. 3 features explain why the Commissioner is asking for something qualitatively different. First, those damages flow to the complainant, not to a regulator enforcing the public interest. Second, the criminal fines are narrow, process failures, not substantive ones. Third, there is no financial penalty anywhere in the current Act for breaching an information privacy principle. Manage My Health operated without mandatory multi-factor authentication and without anomaly detection, capable of flagging an attacker accessing hundreds of thousands of records. The regulatory financial consequence for both failures is 0. In late 2022, Australia experienced the Optus breach, 9.5 million customers affected, and the Medibank breach, 9.7 million members, with health data subsequently published by the attackers. Together, those incidents exposed data belonging to roughly 80% of Australia's population. Australia's Parliament raised the maximum penalty for serious privacy violations to 50 million Australian dollars, or 3 times the benefit obtained, or 30% of adjusted turnover. The Australian Information Commissioner filed civil penalty proceedings against Medibank. Proceedings were ongoing as of June 2026. The Australian Clinical Labs precedent, a 5.8 million Australian dollar penalty in 2025, confirms the reformed regime is producing outcomes at scale. The EU General Data Protection Regulation allows administrative fines of up to 20 million euros or 4% of an entity's global annual turnover. South Korean regulators imposed approximately 710 million New Zealand dollars against Coupang in June 2026, driven in part by deliberate destruction of access logs after a preservation order was issued. New Zealand's maximum procedural criminal fine is approximately 5,000 times smaller than Australia's penalty floor for the same class of breach. Before we go further, the Lethal by Design series is running on Fridays right now on this channel, applying the identical accountability gap analysis to military AI and autonomous weapon systems. Episode 6 publishes Friday the 31st of July. The architecture of ungoverned accountability is the same regardless of domain. The Commissioner's 4th of June request is not a lone voice asking Parliament to act from a standing start. 3 distinct government processes are converging on the civil penalty question simultaneously. First, Action 8 of the DPMC's Cybersecurity Action Plan 2026 to 2027 formally tasks the Ministry of Justice with advising on options to introduce a FISMIT, civil pecuniary penalty regime, to the Privacy Act. The government has already identified the mechanism, an advisory process is underway, and reform requires that process to complete before a bill can be drafted. Second, the DPMC's consultation on mandatory critical infrastructure cybersecurity, which closed in April 2026, proposes a corporate penalty of the greater of 5 million New Zealand dollars or 2% of turnover, plus director personal liability of up to $500,000. If the health sector is designated critical infrastructure, the exposure for organizations handling sensitive health data shifts materially. Third, the Phase 2 Manage My Health inquiry will examine the real-world impact of the breach. Authorization practices, data retention, notification compliance, and whether the breach caused disproportionate harm to Northland Maori. Phase 2 findings will add political and regulatory pressure to the civil penalty question as they publish. Under the current Act, the financial cost of a serious security failure is remediation plus reputational harm. The compliance notice requires an organization to fix what it should have fixed before the breach, remove the penalty, and you reduce the economic case for the pre-breach investment. This is not an inference from first principles. It is a structural feature of the current enforcement architecture. An organization that reports a serious breach promptly faces a compliance notice and potential tribunal referral. An organization that reports the same breach with adequate controls in place faces no regulatory action. The financial consequence of having inadequate controls and suffering a breach is zero at the regulatory level. The once-only resilience framework this series introduced establishes that organizations get one opportunity to build resilience before an incident. The Commissioner's argument for fining powers is the regulatory design equivalent. The deterrent must exist before the breach. New Zealand's National Cybersecurity Advisory Body, operating through New Zealand's contribution to the Five Eyes intelligence sharing framework, consistently identifies health records and sensitive personal data as priority collection targets for state-aligned threat actors. The Manage My Health breach required no sophisticated intrusion, valid credentials, records accessed at a volume no anomaly detection system flagged, credential-based, sustained, invisible to passive controls, an enforcement architecture that attaches no financial consequence to that controls gap does not alter the deterrence calculation for low attribution data collection. 2 points follow from this analysis, and both are actionable before Parliament moves. The first is that the risk already exists. Director liability under Companies Act, Section 137, does not wait for civil penalties to be enacted. Boards governing organizations that hold sensitive personal data have fiduciary obligations today. Under the current law, those obligations are not satisfied by delegating the governance question to compliance teams or relying on contractual assurances from vendors. The second point, the reform timeline is uncertain, but the direction is not. The Ministry of Justice is tasked to advise. The DPMC consultation has proposed $5 million penalties in the adjacent critical infrastructure domain. Public survey evidence suggests 3/4 of New Zealanders would support granting the Commissioner the power to impose fines for serious privacy failures. The board questions are concrete. Is multi-factor authentication mandatory on every interface where personal information is accessible, including third-party vendor portals? Does anomaly detection cover credential-based access patterns at scale, not just perimeter detection? What is the vendor assurance program for third-party processors holding personal data? Is the board receiving regular reporting on Information Privacy Principle 5 compliance? And what is the governance plan for the 12 months before a civil penalty regime might arrive? Because the governance duty exists now. The Privacy Act was not designed for an era in which a third-party vendor could hold access to 1.8 million registered users' health records and suffer a credential-based breach that ran undetected for an extended period. The Commissioner is asking Parliament to repay that legislative debt. 3 numbers to carry out of this episode. 10,000, the current maximum fine for failing to tell the Commissioner about a breach. 99,416, the patients whose health records were accessed in the Manage My Health breach. Approximately 5,000, the multiple by which New Zealand's enforcement ceiling is smaller than Australia's penalty floor for the same class of incident. The enforcement architecture is changing. The question for boards is whether the governance architecture is keeping pace. The fiduciary duty exists now, the fine is coming. The 12 months before enactment is the window to act.
That is the Hamberger report for today. If this was useful, subscribe and hit the like button. It helps more professionals find the channel. You will find links to everything we covered in the description below. I am Andreas Hamberger, and I will see you tomorrow.
Like and subscribe.